you didn't agree to a blood test, typically what would happen is the police officers would get a warrant, and that warrant would be from a judge. They would basically be telling the judge why they need the judge's permission to draw the blood, basically because evidence is disappearing. So even if you refuse to do the chemical test, you can, end up being convicted of a DUI for drugs, if there are drugs in your system. Typically, what happens in these cases is the officers, they'll do a preliminary breath test and see there's no alcohol in your system. Or if you refuse one and they're not smelling the odor of an alcoholic beverage on you, but you're acting in ways that make them think that you're on drugs, they'll arrest you for DUI drugs. And then they'll get this warrant from the judge if you don't agree to do a blood test. Because once you've been arrested for a DUI, you have to do either a breath or blood test. And if you don't, you lose your license for a year. And the cops can take away the option of the breath test if they think that you're on drugs and it's not alcohol, and they want to, or if it's a combination of both, then they can say, we're only offering you the blood test. Now, in those situations, even though you didn't agree, they get the warrant, and they get the warrant from the judge in Marin County, and it's whoever the duty judge is. And usually these cases happen late at night, but it can be any time of the day. And they're supposed to show you the warrant, and it will say that the judge is basically telling you you're ordered by the court to submit to this test. If you refuse to, the officers can hold you down, and they can do a forced blood draw, or they can choose not to draw the blood, and they can still go after you for a DUI, but they're going to have a lot less evidence if they don't have the actual blood test results for drugs. So typically they will, do the blood draw, and if you are over the therapeutic level, and if they have other evidence, they can, the DA can file charges, and they will try and prosecute you and convict you of DUI drugs. This is where the DUI defense attorney, someone like myself who practices DUI law, DUI defense in Marin County and in the San Francisco Bay Area, and within the court systems, and also with the Department of Motor Vehicles to try and save the licenses. This is where I come in. And what I do is I put the DA's office to their burden to make sure that they can show all the elements of the offense are present. And if they can show beyond a reasonable doubt that you were driving, and that while you were driving, you were either at or over 0.08 blood alcohol level, or that you were under the influence of alcohol or drugs, or the combined influence, then you will be convicted. You can be convicted of a DUI. And in this case, going back to the original question, DUI drugs. A lot of people ask me, and unfortunately it's usually after they've been arrested, but do they have to take a chemical test if arrested for a DUI? And the answer is, you're going to lose your license for a year. We get a hearing with the DMV, but typically you're going to lose that license for a year if you refuse to take the chemical test after you've been arrested for a DUI. The cops admonish you. If they properly admonish you, then typically the DMV in those cases will take away your license for a year. And we get to fight that, and we can win some of those, and there are different ways to win those, but nothing's guaranteed, and they're very tough cases. So typically in these cases, your best bet is not to refuse a chemical test, because the penalty, especially driving-wise, is typically going to be a lot less than if you refuse the chemical test.